court case, the Constitutional Court has dismissed another application by Treasury in relation to tenders and government procurement. Treasury was applying for direct access to the court on an urgent basis. This after the Supreme Court earlier declared that the Finance Minister had gone beyond his scope of powers by introducing procurement regulations that allowed for tendering organisations to be pre-qualified. An organ of state could therefore pre-qualify or disqualify any company bidding for government business that does not meet required BBBEE or other potential targets. We're now joined by Molefe Fani, National Treasury Acting Procurement Officer. Mr. Fani, thank you very much for being with us. Can you explain exactly what this judgment means for Treasury?
Good evening, and good evening to the viewers as well. What this basically means is that we are reverting back as government to the preferential procurement regulations that were published in 2017, which were declared invalid by the Supreme Court and were upheld by the Constitutional Court. What we had done was we had gone to the Constitutional Court to seek clarity on the validity of the time period that we require to correct the regulations that were declared to be invalid. While we are correcting the errors that we have committed or the blind spots that were picked up by the Constitutional Court, we have the period right up until the 15th of February of 2023 to correct all those errors that were picked up in the judgment by the Constitutional Court. All
right, so effectively the 2017 regulations around this pre-qualification remain invalid. You haven't been able to overturn that?
We have not been able to overturn that. What the Supreme Court has made as a judgment was that 3B, 4 and 9 were declared invalid, and because of their interconnectedness with the rest of the regulations that were issued in 2017, then the Supreme Court then declared all the regulations to be invalid, and the Constitutional Court upheld that. But we do have the period to correct what has been declared invalid. In fact, the Constitutional Court made a judgment that the Minister of Finance should not have and has no authority to issue the regulations in the form that it was. Therefore, the organs of states would have to issue their own procurement policies. What we are going to do is, while we are correcting that and making sure that we guide the organs of states on how to be able to develop their own policies, the current regulations of 2017 will be in effect until the 15th of February of the following year, while we are correcting all these errors.
All right, after the correction, this is very complicated legal arguments here, but essentially the Finance Minister those regulations where he said you cannot pre-qualify any business based on BEE or other credentials will be out of the way. Is that a setback for transformation? What tools then do the state departments have to advance BEE? The big question here is what does it mean for transformation, for government really being an enabler of diversity and BEE?
Well, it sets us back as government because we had anticipated that we will transform procurement in on incremental basis. And we had hoped that these regulations would take us to the next phase where we would issue the new public procurement bill, which will further clarify issues, because we have learned since the issue of the triple PFA and its associated regulations on what we need to do to transform. The areas that are challenged or that are affected include such as the local production and content, which stimulates local manufacturing in the country, and other transformational matters. However, we are hopeful that with the new public procurement bill, we will be in the position to bring about the regulations that will accelerate the transformation that we require. We are elated that the Constitutional Court gave us this period up until the 15th of February, 16th of February rather, to be able to correct or to use the current legislation in their current form while government works and provide procurement and ensure that service delivery happens. And indeed, transformation has to happen.
So when you're trying to correct, you're saying you're still going to try and do it in the right way, but you're still going to try and put in these pre-qualification criteria.
No, it's not what I'm indicating. The pre-qualification criteria has been declared to be invalid. Us bringing it back in its current form would be contempt of court.
Okay.
So
what other ways then can you push transformation as you say you are committed to doing?
We are looking at issues where we will be able to set aside, to bring about reforms, like for instance, set aside of some of the tenders, but that would require us to go up in the hierarchy of the legislation that we've got to fix it up there and bring it down in the regulations as well as in the instructions that we would use. That is work under progress, and we will make sure that we produce the public procurement bill as well as associated secondary regulations that will be compliant to the Supreme Court as well as the Constitutional Court ruling.
Agribusiness launched this application. They are the ones that opposed these regulations. But I see in the court judgment, the Rule of Law Project was also there, and the Economic Freedom Fighters. What were their interests in this court case?
It's only a single entry where they seek to have and ensure that there is transformation of procurement, and in agreement with us that the regulations, when we put them at that time, the objective was pure. The objective was indeed in making sure that suppliers of goods and services to government that are not keen to transform their procurement base and ensure that they respond to the transformational agenda of government, do not take up opportunities that government presents to those that are keen to ensure that this country moves forward in terms of its transformation. We are aware of the issues of women, we are aware of issues of youth, we are aware of issues of people with disabilities, and that's exactly what we're intending to do moving forward in ensuring that our legislation is transformatory in nature.
All right, thank you for that explanation, Molefe Fani, National Treasury Acting Procurement Officer.